Let's kick off this hour with news on the removal of conditions on green card. This is a favorite topic of our famous attorney on our screen by the name of Attorney Ramesh Khurana. You will now get to hear more on this subject matter from Attorney Khurana in this famous segment called Business and Immigration Law Updates. Attorney Khurana is the Chief Attorney and Counselor at Law at the Khurana Law Firm. This is conveniently located in Gaithersburg, Maryland. The moderator here is Attorney Kenneth Haber, who hails from Boyds, Maryland. Let's tune in to this legal discussion.
Welcome. My name's Kenneth Haber. I'm a former Assistant United States Attorney and a former Senior Attorney in the Office of Inspector General of the United States Department of Health and Human Services, the Medicare cops. With me today we have Ramesh Khurana, a renowned immigration attorney right here in the D.C. area, Rockville, Maryland, and Gaithersburg, Maryland nowadays.
Yeah, office moved.
Gaithersburg, office
Yeah.
moved.
Yeah.
And he's here to discuss with us the removal of conditions on a green card, and this is the Capitol Forum. Welcome, Ramesh.
Thank you, Ken. I love this topic, Ken.
I know, and I love getting the conditions on my wife's green card removed when,
There you go.
when we were
There
in the
you go.
process.
There you go.
Can you tell the audience a little bit about this, our viewing audience? What is a conditional green card?
Right. You know, conditional green card can be issued in several situations, but I think you are just referring to the marriage-based green card when you refer to your wife's case.
Yes.
So, when a couple gets married and on the date of adjudication of the green card application of the beneficiary, if the marriage is not more than 2 years, then this couple or I would say the beneficiary of green card petition is entitled only for a conditional green card. That means it is valid only for a period of 2 years. Now your question will be, why only for 2 years? The reason is so many frauds are taking place, so many people are abusing the system, as we have discussed in a separate session. So USCIS would like to revisit after 2 years before they will decide to issue a regular card, and the regular green card is issued for 10 years. So that's why they have created another process after 2 years or after or close to the expiry of second anniversary of the green card to examine the case again, just to make sure it was a bona fide marriage.
Very good. And what's the procedure to remove this restriction or condition on the green card? How complicated is it?
Let me make a statement at the outset. If the marriage is bona fide and valid, so naturally there is so much documentation which can be supported with the petition. Now the conditional green card holder has to file what we call is Form I-751. If both the husband and wife they are together, then of course both of them are going to sign this form, and if they have separated, there may be a situation, although it was a bona fide marriage, but it was not a viable one. There may be a genuine marriage, but somehow there were, let's say, irreconcilable differences, or there were some other marital issues, that couple is not living together or couple is divorced, still the application for condition of removal can be filed. So you have to file this application during the 90-day period when the expiry date comes. It should not be later than the 90-day period, because then you lose your status. But it should not be before 90 days either. If the application is received 91 days before the expiry date, then that petition will be rejected and package will be sent back by the Department of Homeland Security.
So it's got to be sometime within the 90 days.
Within 90 days. Usually what we do, we will mail out the package on the 91st day, so that when day it reaches, this is the 90th day. And we will get the receipt notice in 7 days, 10 days, depending upon, what's the time period? Sometimes it's closer to December or January, then things get slowed down a little bit because some of the people, they are on vacation, like they have to distribute the work to the available staff, but otherwise receipt notice comes in 7 to 10 days. Yeah.
Are you eligible to apply for removal of the green card if you're no longer married to a person?
Yes, Ken, if you are no longer married, that means you have been divorced. So yes, then you have to apply and seek a waiver of the joint application, because your husband or wife is not there to sign the application because you are already divorced. Sometimes a person would come to us and he or she would tell us that they are going through the separation process, they are not yet divorced. Unless there are certain grounds on which probably we can file even before the divorce is possible. Otherwise, we advise the couple, first of all, get the divorce order from the court and then come to us. It depends, because let's say if there was an allegation of vicious conduct and there may be a case of adultery. In these kinds of situations, as you know, even for the purpose of divorce, no separation is required, like?
Right.
So, in those kinds of situations, we can explain it that it's because of the vicious conduct the divorce petition has been filed or will be filed, but the case is ripe for the purpose of waiver of condition because second person will not sign it. So, we explain all the circumstances. So, we have to document it very heavily, Ken. You know, we have to show, like if we are saying it's because of vicious conduct, so you have to look at it. If any 911 call was made by the spouse or there any other legal action was going on, so there are any pictures, and again depending upon, first of all, is the bona fide marriage which you have to show. If some children are born out of the marriage, that those birth certificates can be given of the children, some children pictures can be given in support of the petition to show that it was a bona fide marriage, but somehow this has not proven to be a viable marriage. Then of course you have to show when you are filing based on the waiver that if this person has to go back to the country, what kind of extreme hardship is involved. Let us say this person has been living here for several years, even before marriage. She was in a different kind of status and marriage is now 1.5 years old. Then you make that argument that this person has become used to this kind of American way of life, dreams, or the entire family has moved under different circumstances and there are no ties with the home country. So, you explain all those conditions. You also explain how are the health conditions in that particular country and what is the job situation if this person has to go back, in order to document that really there will be an extreme hardship to this person if this person were to be sent back.
Ramesh, what if a couple have been legitimately married and they're getting along well, but they're no longer in love? Let's just say that he fell in love with somebody else and maybe she fell in love with somebody else too. And they want to cooperate in terms of the divorce and they want to cooperate in terms of her immigration status. What can they do about that?
Ken, as per your fact pattern, they are still living together and
Yes.
they are husband and wife.
They're still husband and wife.
So, there is no need to seek the waiver because as you say, they want to cooperate. So, that means both of them are willing to sign the application form for removal of condition, which is form I-751. But still, as my ethical responsibility, if that person tells me that we have irreconcilable differences and we have decided to separate and we have decided to seek divorce, I would like to make that kind of statement on behalf of both the persons that this is what has happened, I mean, it's not going to stop the removal of the condition, only because that shows that there was a bona fide marriage, as you said, legitimate marriage, and there are no questions about it. And now, because of irreconcilable differences, they have decided to choose their own ways. It happens because you just cannot bind the people if they think that they are not made for each other, or they are done, or one of them falls in love with somebody else. You know, it happens. It's a natural desire of the people to enjoy their lives. But the purpose of removal of condition on green card is, as I said in my opening remarks, is to make sure that these marriages are bona fide and no immigration benefit is given by US citizen spouses just because that person needs some help in a situation, that person doesn't have any kind of immigration status. So, I don't think that it will stop the removal of the condition, but explain all the circumstances.
What happens if the applicant, the wife, whoever the beneficiary, is late in filing the application for removal of condition? What are the consequences of that?
You know, as we discussed, Ken, I always recommend, because it's required, that you need to file within the 90-day period before the second anniversary expires, which is given on the green card. But if for some reasons you are unable to do that, you have to document that reason. You have to give some good cause, like why did you fail to file for removal of condition within the 90-day period? And let us say if somebody was terminally sick in the family and your full attention is focused on that family member, so it becomes a good reason. Or you know, that applicant himself or herself got into some medical issues, you never know. So, you have to really give some good cause for the purpose, so that you can show that what exactly happened here which caused basically delay in the filing of this application. You know, one thing I tell you, I handled several cases where people have been late, but there were really some genuine reasons to support the argument, and I was able to document all those reasons and I was successful.
What happens once the condition of on the green card is removed by the Homeland Securities? Where are you at that point in time?
Sure. You know, the green card is issued for 2 years. So, once the condition is removed, a regular green card with the validity period of 10 years is issued. And when you file the application, they send you the receipt notice and the authorization, which is valid to work for 1 year. Basically, it's a kind of green card. And based on that document, you can also travel internationally. There's absolutely no problem. Or sometimes we recommend, just to be on the safe side, that make an info pass appointment with the local USCIS office and go and get I-551 stamp in your passport, which is basically the green card stamp. So, if you have taken these steps, you can have international travel, you have the green card status until such time the decision is made, maybe 8 months, 10 months nowadays. This is the normal processing time.
Very good. I'd like to thank you for coming on in and explaining these to our viewing audience. I'm sure that these issues are very close to the hearts of many people, because we have so many people coming into this country and are marrying into this country that is the type of thing they're probably concerned about.
It's a very important aspect of the green card, and in fact USCIS would also send a letter at least 4 months in advance. Of course, they don't have any obligation, but they do send a letter reminding this kind of green card holder that this is a time for you to file for removal of condition.
And you need to have a current address, change of address in there.
That's right. Otherwise, you will miss that communication from USCIS.
And then you'll be out of luck.
That's right.
I'd like to thank you very much.
Thank you.
And I thank you for our viewing audience.
Thank you.